All right, welcome back. Thank you so much for staying with us right here on Morning Cafe. My name is Anne Odida, and right about now we want to talk about legal grounds for suing your employer after resignation. And to help us understand this is Evans Ndong, a lawyer. Good morning, Evans.
Good morning, Anne. How are you?
Good, karibu sana. So, I want us to get right into this discussion. What are some of the valid grounds, legal valid grounds for an employee to sue their employer after resignation?
Now, I must first start this conversation by saying that many a times people are used to grounds that you sue your employer when you have been sacked. Or when definitely you've been told your time here is over and you've been sacked.
Yeah.
But many people are not aware that even when you decide to pen that resignation letter at the place of work, it is possible for you to sue. A number of grounds will depend on different circumstances in which you can sue when you have resigned. And the most common ground is payment of terminal dues. Remember, when you resign under any circumstances, the contract specifies certain things that you need to be paid. For instance, the annual leave, whether you actually utilize all the period for your annual leave. So your annual leave, ought to be paid. If there is a medical scheme or the contract provides for a medical scheme or an insurance terms, particular terms that you didn't utilize, that too you ought to be paid. If there are any pending, salary dues or allowances, all those ought to be paid. So normally, when a person resigns, either voluntarily or under different circumstances, there are things that the employer needs to do. The terms of the contract will always specify certain benefits that the employee needs to part way with. Now, usually you will find that most of the times the employers don't do that. You take your resignation letter, especially if they feel that you ought not to have resigned. But again, the courts have told us you can't, prevent somebody from resigning. So if I decide to resign, the most important thing is please pay me all the dues that I'm supposed to be paid as part of the contract.
Yeah.
So those are the valid grounds. One can sue based on the terminal dues, allowances that have not been paid, annual leave that has not been utilized that ought to be paid, benefits that would accrue that were part of the contract that was supposed to be paid ought to be paid. If the same is not done, you can go to the Employment and Labor Relations Court and get remedy.
Right. Now, we hear about constructive dismissal and just maybe regular dismissal.
Yes.
How different are they, and are they a basis to file for a legal suit?
Definitely. They are a very strong basis. And in the old days, they used to say, akufukuzae hakuambii toka. So the common phrase, akufukuzae hakuambii toka, is actually what we refer to as constructive dismissal. It is a situation where the employer makes the workplace or the conditions or the terms of the work so untenable that it would not be possible for you to continue working. And therefore you decide to do what? To resign. That would not be a voluntary resignation. So constructive dismissal is more often non-voluntary resignation that has been caused by conditions that have been made so hard or so untenable that it would not be possible for you to continue working. I'll give you a common example that we've seen in both the corporate sector and even in the sales sector. There are circumstances where there are sexual advances towards the employee, by his bosses or her bosses, in a manner that it will not be possible for you to continue working. So you decide that, I cannot take this anymore, and I decide that I will opt out. That would be constructive dismissal. The conditions have been made so hard that by yourself you decide to bow out. In such circumstances, you can actually sue and demonstrate to the court that indeed your resignation came under pressure, it came under conditions that were made too hard, or the terms of the contract under which you were employed were fundamentally varied, that it was not possible for you to continue working, and so you decided to bow out. However, in regular resignation or dismissal, there are two ways. You can decide to pen a letter voluntarily and take to your employer and say, okay, I have decided to resign. Okay, the reasons notwithstanding. Many times, even personal reasons, the employer has no option but to let you go. But there is also regular dismissal, where you called for a disciplinary hearing, you've been heard, and you have been found to have done something, and therefore they decide to let you off the employment. So that is the difference. One will be voluntary, the other would be non-voluntary. And non-voluntary, why? Non-voluntary because the conditions or the situation have been made so untenable. Yes.
Now we're talking about someone resigning because of toxic work environment. The judicial system in Kenya can sometimes be very much unpredictable. We've seen cases being dismissed because of maybe lack of enough evidence. Now, how can an employer in this case prove that maybe they are resigning from their workplace because of harassment or maybe discrimination as well at the workplace?
I think, as opposed to how it used to be before, where the main mode of evidence used to be documentary evidence, where you must have physical evidence, which sometimes may be even very difficult. I have seen cases where, for instance, somebody seeks to demonstrate that they have always been harassed, in their offices, they have been assaulted, physically assaulted. It becomes very difficult because you find that the same entity that employs you cannot be ready to produce the CCTV cameras that attest to those actions. So normally what I would always advise those that feel they are working under a toxic environment, in terms of at least having evidence to demonstrate that the environment was toxic, is that more often toxic environment will always not only be verbal. You will find that you'll receive messages, intimidating messages, and sometimes your colleagues know what is going on. So more often you will always find that if you have like text messages, you've often received text messages reprimanding you, telling you this, despite you doing this, and then also colleagues. There could be colleagues who are ready to give testimony. There could be colleagues who are ready to give testimony. There was a very important case in one of these big warehouses in Kenya, sales warehouses in Kenya, that I will not mention on air, where a toxic environment was created as a result of the superiors sending suggestive, texts to the juniors. So this lady opted out of her employment after 8 months. Now, within these 8 months, she was able to demonstrate to the court that incessantly she used to receive text messages, suggestive text messages that would coerce her into sexual behavior and all this. So more often right now in the era of technology, as they say on the streets, it is good to keep the receipts. Yes.
You mentioned something about sexual harassment in the workplace as well. And you see, this employer has addressed this with the employer or superiors at work, and nothing has been done about it. So what can they do in such a situation?
My advice is that the law as structured, Anne, is that you don't just wake up on one day and go to court. You don't say that these people have created a toxic sexual environment and harassment for me, and therefore the next day you are getting to an advocate's office and you are filing a case. It is always important that if the workplace has disciplinary mechanisms, you utilize these disciplinary mechanisms. The reason why this is important is because sometimes you may rush to court as you would want to, because what happens when people are harassed at work, a lot of emotional energy goes into it. Therefore, you feel like you want to run to court and teach them a lesson. Before you teach them a lesson, you need to ask yourself, are there any disciplinary procedures or reporting procedures within the workplace? Is there a mechanism that has been created by the employment policies, because they are internal employment policies, where when you first feel, for instance, that you are sexually harassed, by the way, it is a matter of policy in this country, and the law requires that if you have 15 to 20 employees, more than 20 employees, you must have a sexual harassment policy at the workplace. So it means that in every big organization, there must always be a sexual harassment policy. That sexual harassment policy will give mechanisms, will give reporting procedures, will give disciplinary mechanisms under which you have to process your complaint first. If you are not heard under those channels, or you feel you have unsatisfactorily been heard, or you've been heard and the actions still continue, then you have the avenue then to approach the Employment and Labor Relations Court. So it is always important that the starting point is not the court process. It is always important that you utilize the mechanisms that have been provided within, and then once you feel those mechanisms have not served you, then you move to the court.
In a case where there's no mechanism such as the ones you're talking about, not in only when there's sexual harassment, but let's talk about bullying, discrimination, maybe favoritism in the workplace. What if it backfires on this employee?
As it always does, Anne. It always backfires. Because internally, when you raise complaint, it's normal in any organization. Normally, when you raise a complaint, however genuine, that is likely to adversely affect the public image of the organization, there are always retaliatory tactics by employers, where either you are suspended, either you are intimidated, either your salary is cut, you're being given threats. So ideally the ideal situation is this: you only utilize the internal mechanisms if those internal mechanisms are able to serve you. And again, if the issues you are raising are issues of constitutional violation on fair labor practices, the law does not require you mandatorily to use the internal mechanisms. Why? Because if any of your constitutional rights have been violated, the internal mechanisms are not able to offer remedy for that. It is only the High Court that can offer sufficient remedy. So you only utilize the layout mechanisms if those layout mechanisms are effective to address the issues that you are raising. If the issues you are raising, for instance, are that there is an appeal mechanism and you are raising the issues that you are not given fair hearing, and they don't want to hear you, you see, that is, for your rights to be vindicated, then you need to move directly to the High Court. So you only utilize these internal mechanisms if what I've told you will not take place. You know, there is an environment of intimidation, retaliatory tactics by the employer. You utilize them if you have been given an amiable opportunity. There are even circumstances where you raise an issue, but you are not being given hearing. You're just being told they respond to the issue you raise. No hearing, no witnesses have been called at all, you know, to be grilled on whether these things are true or even the slightest form of investigations. So these things will always vary from case to case. A court will always make a determination on case-to-case basis and determine whether the internal remedy was indeed sufficient. Because mostly it is the employers who will always raise the issue that you did not utilize the internal processes. But if you can demonstrate to the court that the internal processes were not going to serve your interest or were not sufficiently, even a slightest glimpse or an attempt to solve your issue, the court will hear you.
So what steps should be taken to ensure that this employer strengthens their case so much? They see backfire, and then also for just a potential lawsuit before resigning, that is?
No, before resigning, I think it is important that if you are resigning in a manner that you contemplate, okay, that there is a level of unfairness that is going to come out of it, I normally advise that it is important to keep all your records. Keep all your records. And if you are resigning, don't resign by implication. Resign. If you are resigning regularly, resign by writing a letter clearly. If you are resigning by constructive dismissal, in fact, Anne, you do not need to write a letter if you are resigning by constructive dismissal. If you decide to stop going to work because the conditions of work is untenable, you don't even need to write a letter. Why? Because provided you can demonstrate to the court, at least in the slightest evidentiary threshold, that either, for instance, I would give you an example. Somebody gets a job, then their salary midway is fundamentally varied. They raise this issue with the employer does not want to listen. Or their times of work, you've been told you'll only work 8 hours in a day. They decide to make it 17 or 12 or 13. Those conditions have made your work so untenable that even if you don't write a letter and you just quit without writing a letter, the court will still make a determination and find that it is constructive dismissal. So as an employee, for you to strengthen your case, you must demonstrate that, one, there were favorable terms under which you were employed, for instance, or there were normal conditions, you know, that you did not agree to at the beginning. They have been varied or they have been made more severe midway. So that is why it is important always to keep your contract and have it. And more importantly, read the terms of the contract and understand it. If you don't agree with any parts of your employment contract, raise an issue at an earliest opportunity, because you cannot then come later and say, okay, you people, I didn't read this at the time I was taking up the employment. That would not be a defense.
Yeah. So can an employer now sue the employee for resigning just abruptly without taking into consideration these things that are in the contracts, and you say sometimes mtu hawezi kuwa amesoma the contract.
Yes.
So can an employer sue in such a situation?
Definitely. An employer can sue. And most likely the employer will be successful, especially, you know, the most fundamental thing in terms of a contract and its resignation procedures is the timelines provided thereunder. There are contracts that provides, for instance, that you must give 30 days notice to your employer. You're about to resign. And in that way, you will be then entitled to your monthly salary in lieu, or you will be entitled to those benefits. You will find that the benefits upon which you want to hinge your claim as an employee always have a specification. There are particular timelines under which you're supposed to do certain things. An employer can actually sue and recover damages if you violate, because you see, this is a contract. It's like a normal contract, and parties have obligations, parties have responsibilities, and parties have rights. The employee has rights, the employer has rights. What is more important for the employee is that the employee ensures all the timelines. If it is 30 days, you give notice. If you've gotten a new job and the notice is 30 days in lieu of that job, you give notice before you sign that other contract. Otherwise, if you transition without doing so, you will forfeit all the benefits, because those benefits are normally tied to certain procedures and timelines. There are some jobs also you will find that you'll not be given benefits and everything before you hand over, you know, especially in the managerial positions. If you don't hand over and finish up things, there are certain benefits that you are not likely to be entitled to. So you just ensure on your part, you keep on the timelines and do them well. In that way, you lock the very position that an employer might take you to court or might decide not to pay you your dues.
So what are the timelines within which an employer should file for a lawsuit after resignation? Now,
it depends. The normalcy is this, that employment lawsuits are normally having a time limitation of 3 years. That is the normalcy for the employment suits. Employment suits must be raised within a span of 3 years.
Yeah.
However, the advice is this, that one ought to then raise, you know, their employment claims within the shortest time possible. Because there are circumstances when, in fact, the court can extend the period under which you can lodge an employment lawsuit. That is also important. If you look at Section 90 of the ELC, the Employment Act of 2007, there are also circumstances beyond that 3 years where the court can say, we have the discretion to extend this period. Why? Because there are circumstances you want to go to court and it is your employer, in fact, who has made the access to the documents you want to use so difficult that you're not likely to access any of them. So the court can exercise discretion under certain circumstances to extend for you that time. But normally it's within, that claim must be raised in 3 years. Yes.
Now, Wakili, we have a question here for you from Brian, and he's asking,
yes,
he's a contract sphere. Can an employee have their terms ama niza employer any final?
Interesting. And I perhaps understand the background of why Brian is asking that question. He's asking that question because, and the truth is this, the Employment Act of 2007 has made the terms so protectionist of the employee more than the employer. That is the truth. And there is a good reason for that, because in labor laws, there is always a presumption that, in fact, the employer already has a higher bargain. And therefore, the law seeks to balance the scale. So the terms are both ways. The terms are both for the employer and the terms are both for the employee. But the truth is, the employer has a more duty, okay, under the contract. If you look at the obligations that have been placed on the employer under the Employment Act, the notices, even the process of hearing alone, I can demonstrate it to you with the process of hearing. The process of hearing alone tells you that the employer has a very high threshold under the Act, because he has to give you notice, you have to get to the hearing, you have to be heard fairly, you have to be given time to face your accusers if they are complainants. And then a decision has to be made, you have to be told of an appellate mechanism where you can appeal internally. Once you're done, then you can then move out. So yes, the terms are both ways. See, kwamba an employee is final or an employer is final. The terms are both ways, but there is a more duty on the employer.
Yeah. You know, Jory has a follow-up question on that. This
Yes.
is Jory asking you this question. And she's saying the disciplinary hearing, how should it go? And the process, kukua summoned for one. That is a disciplinary hearing.
A disciplinary hearing will depend on contracts, but the Employment Act at least has given us some bare minimums on what ought to take place. The salient elements of a disciplinary hearing is that, number one, you have to be informed of the complaint within a good time. You have to be given that initial information, let alone being called for the hearing. You have to be, if it's a letter, you have to be notified that, look, there is a complaint that is arising, you know, on this matter, and that soon you will be called for a hearing. So notification is important. You have to be notified of that disciplinary hearing way earlier, in a manner that allows you to have enough time to prepare to defend yourself. Then you must be given time to prepare your defense upon being called for hearing. If there are witnesses involved, you must be given time either to be represented or you represent yourself and grill your witnesses. You ask them questions, you interrogate them. The disciplinary committee or whatever, the tribunal or a panel, different employers have different names for it, must make a decision which must be communicated to you. And it must not just be a single line decision the way you see employers doing, you are fired. There's nothing called you are fired. You must make a well-reasoned decision. We have heard you, we have gone through the evidence, this and this and this. This is how the proceeding took place. We have then determined that you are guilty on this ground. In fact, Anne, even when you are accused on an array of allegations, you cannot, by bandwagon, just tell you are fired on all of them. There must be a finding on each of them. Should there even be a finding, a lack of finding on any of them, they must return a verdict. If they don't return a verdict, then you are not being given fair hearing. So representation is important. Time, you must be given time to defend yourself. Very important. You must also be given time to interrogate your witnesses if they are there. Very important. And more importantly, a reasoned decision with reasons must be communicated to you.
Now tell us about the cost implication on these employees seeking legal action. How expensive or cheap is this?
Now that is an interesting question. I think generally the Kenyan legal system is expensive. It's generally expensive. However, on the part of the legal fees for the advocates, that is a different issue because there is a specific law that stipulates how they charge. And that law also depends with the nature of the suit. The more complex, the more higher it will be. For instance, how you want to file a suit for, let's say, a general manager would fundamentally vary from how, the cost implications of a suit for, let's say, technical advisor would be, or those who are in non-management roles. So the cost, Anne, will depend on, one, the complexity of the matter, the nature of the case, the position of the person, or the circumstances. There are circumstances, for instance, where a whole group of, let's say, 500 people have been sacked. That would be a bit more complex and a bit more costly. But the assurance is this: when it comes to court costs, what you now actually pay in case you want to file the case by yourself, because there are people who actually decide to file the cases by themselves, the cost implication is not very high, especially if you take it as a constitutional petition for vindication of your rights and not a normal employment claim. So the court costs are not as high, but this will vary depending with the nature and the complexity of the matter.
Now, is an employer now legally required to provide reference after resignation? And what can this employee do in case of a defamation?
Interesting. Yes, it is possible that an employer can give reference even after your resignation. Now, the nature of that reference now will vary. Generally, a reference should be truthful. You should not go outside what is not truthful. If lies have been told here that have a potential of tainting your reputation as a person, then you have a recourse. You have a recourse to go to a court of law and sue your former employer for defaming you through references. It is possible. But also let me say something that is important. One more tactic that employers use that I want to tell my viewers is that they normally use the criminal justice system in civil matters to arrest you, bungle you to the police station, and then because of that, use that reason without hearing you, but because you have a case and it's a police case, to then let you off employment. That is part of the blackmail tactics. So that when they write the reference, they say, this employer had this case, and he did this, even when the court has not made a finding. So in such circumstances where a reference then makes reference to a criminal justice system that has not even ended, investigations were not done to the end, or you were let off, or you were acquitted, then you have a role to sue. You can sue for defamation, or you can sue for malicious prosecution. There's something called malicious prosecution. This is a circumstance where you have been arrested for no reason, for intimidation. You see, they find a way out of letting you off employment. And the easiest way is when you have been handcuffed and taken to a police station, and then now they say you have a criminal case, you will taint the image of an organization, then they let you off. So you can either sue for defamation under such circumstances. If reference makes its foundation to be that case, the matter that you arrested, or that in fact they say something out of the blues, stole money, especially those who work in sales, the sales sector. It's very common.
Yeah.
You got away with 900,000, you are a dishonest person. They don't even explain what level of dishonesty that they are referring to. So yes, if a reference then descends into defamation or malicious prosecution, or prosecution maliciously, you can go to court either under defamation or a suit for malicious prosecution.
All right, thank you so much, Evans Dong, a lawyer, for taking time to spend with us here, for taking your time to be here on Morning Cafe. We do appreciate it. We've talked much about this conversation here, and you've mentioned screenshots. Ni muhimu. Keep those evidence.
Keep the receipt.
Keep the receipts.
Yes.
Asante sana. That brings us to the end of Morning Cafe this morning. Do enjoy the rest of your day. Keep it TV 47.